Welcome to the Anthony John Esquire podcast. I am AJ, and today, April Fools, we are going to dive in, rather appropriately, to the Birthright Citizenship case. This is concerning Trump's executive order on birthright citizenship, and it is being argued later this morning in front of the U.S. Supreme Court. So the purpose of this podcast is just to give a sort of background or primer to people who'd like to listen to that oral argument before the Supreme Court and understand what's going on. I can say from previous experience that if you're not familiar with the legal arguments or the cases that the justices and the parties are referencing during oral argument, it's really easy to get lost rather quickly. So the point of today's podcast is just to provide some background for people who want to listen to that, to sort of outline the case and to tell you where I think it should go and where I do see it going. So I'm a little bit reluctant to talk about the case just because the Trump administration's executive order and argument is so blindingly stupid that to talk about it gives it a sort of strength or gravitas that it would not otherwise have. We have all understood forever that people born on the soil of the United States are United States citizens, with a few special exceptions. We learned this from elementary school on. And as a matter of fact, the very thing at issue in today's case was well settled by the U.S. Supreme Court over 125 years ago. So it's kind of mysterious as to why the Trump administration thinks it has a leg to stand on legally. Practically speaking, it's fairly obvious that this sort of blatantly illegal, unconstitutional, we'll do what we want, we'll get to say who's a citizen, we'll get to say what it means to be an American is absolute red meat for his base. And as we saw at the State of the Union, win or lose, he will spin this into some sort of benefit for himself. It's important for the rest of us, however, that he lose, because birthright citizenship is integral to what it means to be an American. So in today's podcast, what we're going to do is look at the executive order, look at the 14th Amendment, we'll look at the cases that apply to those that are going to be argued about today, and discuss them a bit. And we're doing all this, again, just to prepare to understand the oral arguments that are going to occur. We'll take a guess at how the justices are going to vote, regardless of how they should vote, right? So what this case is about, the executive order purports to restrict executive recognition of U.S. citizenship. So various non-citizen folks have won in the lower courts, and Trump appealed. The executive order made the day he took office in his second term is titled Protecting the Meaning and Value of American Citizenship. I'll go through what it says with an occasional interjection about what it actually means. So it reads, by the authority vested in me as president by the Constitution and laws of the United States of America, it is hereby ordered. And that's where I'll stop for the very first time, because as per usual, when it comes to Donald Trump, we can't make it through a single sentence without a lie or a misrepresentation. So what the Constitution actually says about who gets to control citizenship and naturalization is that it's Congress, not the president. That comes from Article 1, Section 8, Clause 4, saying that Congress has the power to establish a uniform rule of naturalization. So there is no power vested in the president by the Constitution concerning this, just to be clear. Going ahead anyway, Section 1, Purpose. The privilege of United States citizenship is a priceless and profound gift. The 14th Amendment states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That provision rightly repudiated the Supreme Court of the United States' shameful decision in Dred Scott versus Sanford, which misinterpreted the Constitution as permanently excluding people of African descent from eligibility for United States citizenship based solely on their race. So, my analysis there is it's all true except for privilege. Citizenship is a right, as we'll discuss, but other than that, he's correct about what the 14th Amendment says and about how wrong Dred Scott was. Going on. But the 14th Amendment has never been interpreted to extend citizenship universally to everyone born within the United States. The 14th Amendment has always excluded from birthright citizenship persons who were born in the United States but not subject to the jurisdiction thereof. Consistent with this understanding, the Congress has further specified through legislation that a person born in the United States and subject to jurisdiction thereof is a national and a citizen of the United States at birth per 8 U.S.C. 1401, generally mirroring the 14th Amendment's text. Now, interjection, technically that's all right, but where he goes with it is obviously wrong. Continuing, among the categories of individuals born in the United States and not subject to the jurisdiction thereof, the privilege of United States citizenship does not automatically extend to persons born in the United States. 1. When that person's mother was unlawfully present in the United States and the father was not a United States citizen or lawful permanent resident at the time of said person's birth, or 2. When that person's mother's presence in the United States at the time of said person's birth was lawful but temporary, such as but not limited to visiting the United States under the auspices of the visa waiver program or visiting on a student, work, or tourist visa, and the father was not a United States citizen or lawful permanent resident at the time of said person's birth. So I will interject here that this is absolute bullshit, not just as a matter of opinion, but as black letter law that's been established for, again, over 125 years, as we'll discuss. Before we move into that, very quickly, Section 2, as it relates to policy. It is the policy of the United States that no department or agency of the United States government shall issue documents recognizing United States citizenship or accept documents issued by state, local, or other governments or authorities purporting to recognize United States citizenship to persons, and it goes up to sections 1 and 2 again. Finally, this section shall apply only to persons who are born within the United States after 30 days from the date of this order. I think that last part, the prospective application only and 30 days after the order, was made in an apparent effort to maybe mitigate some of the inevitable chaos and tumult that would result from this, but I think instead it invites objections based on the incoherence of it and the impracticality of it. And again, this simply isn't something that is within the president's constitutional authority. It is within the authority of Congress alone. I would encourage listeners not to get confused by the mother language in the executive order. Since we're talking about people born here, the mother has to be present, right? So they want to exclude from citizenship people who are born here when their mom is here illegally, or even when she's here legally, but temporarily. But don't get confused that this is somehow sexist because it's talking about mothers and not fathers. There could be an argument, but that's minutia that's way beyond why this is actually an illegal, unconstitutional order. Rather, what this means by talking about the mother and her status is its effect on the child where that child is born. So, the executive order purports to interpret the 14th Amendment. It would therefore be to our benefit to look at what the 14th Amendment says. Fortunately, the only part of the 14th Amendment that this concerns is the very first sentence. And that sentence reads, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That's the first sentence, and that's all that's in dispute. The Constitution itself does not define citizenship, but it makes some important distinctions. So, for instance, Congress members have to have been citizens for a number of years. I think it's 7 for the House and 9 for the Senate. And the Constitution also says that the president needs to be a natural born citizen. I think it's fairly obvious what that means, at least until Trump comes along. So, aside from that, while the Constitution doesn't define citizenship, again, it says that Congress has the power to establish a uniform rule of naturalization. So, how someone becomes a citizen is up to Congress, not the president. And that's about all the Constitution itself has to say about it. So, I find the observation in the Constitution that a president needs to be natural born fairly interesting. From what I've read of the party's arguments, they don't get into it that much. But let's remember that Trump here is the original birther guy, right? So now it's not enough that someone was born here. At least he's being explicit about that now. He's also saying, well, on top of being born here, it matters who your mama was. So you'll note that his executive order doesn't say who is a citizen, but it certainly seeks to cut a lot of folks out of the picture. So the 14th Amendment says you have to be born here and subject to the jurisdiction of the U.S. to be a citizen. That's true. No one doubts that. And as we'll describe in a bit, again, the Supreme Court decided exactly what that meant over 125 years ago. So the very best form of the Trump administration's argument, and I want to present the very best and strongest form of the argument I can, as opposed to watering it down or strawmanning it, because frankly, this argument is just so blindingly stupid, even in its strongest form, that we don't need to weaken it in order to devastate it. So the very best form of the Trump administration's argument is that children of illegal immigrants are not subject to the jurisdiction of the U.S. in the sense that the 14th Amendment requires, because there's this old case about how Indians aren't citizens, and that case said completely subject, meaning that they weren't citizens because they would have dual loyalties to both their tribe and the U.S. That was Elk versus Wilkins back in 1884. And then a little later, there's another case about whether kids born to Chinese immigrants here in the United States are citizens because they resided and were domiciled here. So the Chinese immigrants, with their loyalty to the Emperor of China, nonetheless resided and were domiciled in the United States. And so even though they were immigrants, their child was a citizen. So an illegal immigrant's child is not a citizen because they're not subject to the complete jurisdiction of the U.S. and because their parents aren't able to legally reside and domicile here. That case was U.S. versus Wong Kim Ark back in 1898. So that is the very most generous statement of the Trump administration's position, and it is laughable. It's a bait and switch and switch and switch. And again, I'm reluctant to talk about it because if you're particularly stupid, that best form of that stupid argument might make sense to you and convince you that that's the way things ought to be. But it's not. We decided this a long time ago, and it is absolutely contrary to American law. So the position is wrong whether you're an originalist or a living constitutionalist. In my opinion, originalism should win the day because that's the way that the case that controls this, Wong Kim Ark, was written all the way back in 1898. So to recap where we're at, the executive order is stupid because it can't overrule the Constitution. It just says how the executive is going to interpret it. And it is stupid because it ignores that Congress controls nationalization, not the executive. Maybe the best brief submitted in this case was an amicus brief by 217 Congress people authored by a professor somewhere opposed to the president's interpretation of the 14th Amendment. I didn't read all of the dozens of amicus briefs, but what I read of this one was good. And in my opinion, it could just stop at the executive doesn't determine citizenship. Congress does. As the amicus discusses, Congress has used the same language in much more recent legislation. So now we don't just look at what the terms meant way back when the nation was founded. We also look at what the same terms meant, the same words used meant when they were later used, say, in the 1950s. Ultimately, though, while that is academically interesting, it's going to turn out to be irrelevant because no matter how you cut it, the Trump administration's position is contrary to binding law. So we can't ignore the text, and the subject to the jurisdiction part of the amendment is a unique caveat. The most natural, and in my opinion, the correct reading of it, is that it meant children of diplomats weren't citizens because diplomats aren't under the jurisdiction of the United States, and so their children wouldn't be when they're born here. If you have a French ambassador who happens to have a baby while she's here, she is still a French citizen, and her presence here while she's on the job doesn't mean that her child would get U.S. citizenship. I think that's the most natural reading, and as a matter of fact, that is what the majority of the case law buttresses. So I also want to say, if you just consider the practical ramifications of this executive order, it is so stupid. You could have 10 generations born here, all on United States soil, and still be illegal. Because if the child of an illegal is an illegal, then so is the child of the child of the child, and so on forever. I mean, that's why this is really at its core seemingly just a racist way to make sure that our nation only looks like the people that we want it to look like. And we can always say of, for instance, a black president, just like Donald Trump did, oh, you're not actually a citizen because your lineage isn't pure enough. Make no mistake, that's exactly what this case is about. So let's talk about the two cases at issue. The first one, Elk versus Wilkins from 1884, is something that the Trump administration really wants to hang its hat on for obvious reasons, and for obvious reasons, it's inapplicable and irrelevant. And then we'll talk about the case that does control and actively addresses Elk versus Wilkins, and that case is Wong Kim Ark, decided in 1898, and that's the one that is still good law today. So, backing up, Elk versus Wilkins, about an Indian not being an American because of dual loyalties. That case held that an Indian born into a tribe within the United States was not a U.S. citizen under the 14th Amendment, merely because he later left his tribe, lived among white residents, and submitted himself to U.S. law. The court had reasoned that the citizenship clause covered those born or naturalized in the United States and subject to his jurisdiction, but tribal Indians were not fully subject to that jurisdiction absent some sort of naturalization by treaty or statute. That court read the citizenship clause as intended primarily to secure citizenship for formerly enslaved persons and others born or naturalized in the United States who owed no allegiance to another sovereign. It concluded that Native Americans living in tribal relations owed allegiance to their tribes and were subject to U.S. authority only in a qualified sense, but not the complete jurisdiction contemplated by the amendment. If this were the only case in our history, Trump still wouldn't win because Indians or Native Americans have had, as the next case puts it, a peculiar relationship with the United States that simply isn't applicable to other groups. Well, Trump wants to focus on that. The next case discusses and explains why it doesn't say what Trump is pretending it does. So that next case is United States versus Wong Kim Ark. That is 169 U.S. 649, and again, it is an 1898 case. That case held that the 14th Amendment guarantees birthright citizenship to nearly everyone on U.S. soil, even if the parents are non citizens, so long as the child is not within a recognized exception, such as diplomatic immunity or hostile occupation. The case is the court's leading authority on citizenship by soil, jus soli citizenship, and remains the foundation for the modern rule of birthright citizenship. So in that case, Wong Kim Ark was born in San Francisco to Chinese parents who were lawful residents of the United States, but not diplomats or officials. After traveling to China and returning to the United States, he was denied re-entry on the theory that he was not a citizen. And the court asked whether a child born in the United States to Chinese subjects who were domiciled and carrying on business in the United States is a citizen under the 14th Amendment Citizenship Clause, and the court, of course, answered yes. It held, as the 14th Amendment said, that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. The court read that language in light of the English common law rule within the territory and concluded that Wong Kim Ark was a citizen at birth because he was born in the United States and his parents were not diplomats or foreign officials. And again, that decision established the modern constitutional baseline for birthright citizenship. So the takeaway from that is that if you're born here and your parent isn't a diplomat or the soldier of an occupying enemy army, you are a citizen. So both parties agree that Wong Kim Ark controls, and to the extent that the government wants to pretend it's about residence and domicile, they're counting on the fact that the decision is just too damn long for the average person to read and sift through in order to sell you that lie. The decision is about 30,000 words, which would be about 60 pages, single spaced. Thankfully, that's what I'm here for. I've read it so you don't have to. So let me give you some of the money shots from Wong Kim Ark. First of all, they do an exhaustive summary of how this issue had been treated for the previous 300 years. So again, we're talking about a case 125 years ago. They look at the previous 300 years, so we're talking about over 400 years of history. And that's important because, of course, our country hasn't been around for 400 years. It hadn't been around for 300 years at the time this decision was issued. And so the court, being scrupulous and very detail-oriented, wanted to make sure that we knew exactly what the founders and the authors of the 14th Amendment had meant when they were saying things like under the jurisdiction of. And so to that end, I think the easiest thing to do in order to demonstrate why this case doesn't mean what Trump says it does is to recognize that in terms of the question presented, they talk about Wong Kim Ark's parents having residence and being domiciled at the beginning of the opinion and at the end of it. And then in the 59 pages in between, they talk about every possible permutation under the sun that could possibly affect whether someone is under the jurisdiction of the place where they're born. And so ultimately, it doesn't depend on residence and domicile. And what I'm going to do, it was hard to narrow these down, but I'm going to go ahead with just a few direct quotes to illustrate that this case can't possibly mean what the Trump administration says it does. So, coming straight from Wong Kim Ark. Passing by questions once earnestly controverted, but finally put at rest by the 14th Amendment of the Constitution, it is beyond doubt that before the enactment of the Civil Rights Act of 1866 or the adoption of the Constitutional Amendment, all white persons, at least, born within the sovereignty of the United States, whether children of citizens or of foreigners, excepting only children of ambassadors or public ministers of a foreign government, were native-born citizens of the United States. So that's pretty clear. Another quote: "The distinction between citizenship of the United States and citizenship of a state is clearly recognized and established. Not only may a man be a citizen of the United States without being a citizen of a state, but an important element is necessary to convert the former into the latter. He must reside within the state to make him a citizen of it, but it is only necessary that he should be born or naturalized in the United States to be a citizen of the Union." So again, that's devastating to Trump's argument when they want to say that residence and domicile are required to confer citizenship. The Supreme Court clearly said, nope, residence is required for state citizenship, but not for United States citizenship. So in Wong Kim Ark, the U.S. Supreme Court exhaustively reviews not only its own cases, but cases of lower courts. One of its own cases that it reviews is called Schooner Exchange. It's from 1812, and it discussed exceptions from jurisdiction, meaning 1, immunity from arrest; 2, immunity of foreign ministers; 3, immunity of sailors on a foreign ship in our waters. So just to touch base with reality here for a second, I don't think that Trump is arguing that so-called illegals are diplomats, right? As a matter of fact, Schooner Exchange cuts against that argument when it says, quote, "When private individuals of one nation spread themselves through another as a business or caprice may direct, mingling indiscriminately with the inhabitants of that other, or when merchant vessels enter for the purposes of trade, it would be obviously inconvenient and dangerous to society, and would subject the laws to continual infraction and the government to degradation, if such individuals or merchants did not owe temporary and local allegiance and were not amenable to the jurisdiction of the country." So yeah, it's saying that immigrants, legal or illegal, are subject to the jurisdiction. Back to Wong Kim Ark. I think just a few more quotes will seal the deal. "These considerations confirm the view already expressed in this opinion that the opening sentence of the 14th Amendment is throughout affirmative and declaratory, intended to allay doubts and settle controversies which had arisen, and not to impose any new restrictions upon citizenship." Next quote: "The 14th Amendment of the Constitution, in the declaration that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside, contemplates two sources of citizenship, and two only: birth and naturalization. Citizenship by naturalization can only be acquired by naturalization under the authority and in the forms of law. But citizenship by birth is established by the mere fact of birth under the circumstances defined in the Constitution. Every person born in the United States and subject to the jurisdiction thereof becomes at once a citizen of the United States and needs no naturalization." Another quote: "Interestingly, the power of naturalization vested in Congress by the Constitution is the power to confer citizenship, not a power to take it away." The reason I think that's interesting is if Congress gets to confer citizenship and not take it away, and Congress is the branch designated by the Constitution to be in control of citizenship, how much less then does the executive, who is not vested with the power to determine naturalization, how much less then does the executive have authority to take citizenship away? Answer: obviously, none at all. The final quote, which is at the very end of the Wong Kim Ark decision: "The evident intention and the necessary effect of the submission of this case to the decision of the court upon the facts agreed by the parties were to present for determination the single question stated at the beginning of this opinion, namely, whether a child born in the United States of parents of Chinese descent, who at the time of his birth are subjects to the Emperor of China, but have a permanent domicile and residence in the United States, and are there carrying on business, and are not employed in any diplomatic or official capacity under the Emperor of China, becomes at the time of his birth a citizen of the United States. For the reasons stated above, this court is of the opinion that the question must be answered in the affirmative." So Trump wants to cling on the domicile and permanent residence aspect of that final paragraph and of the opening paragraph, but so many of the descriptions examined at length had nothing to do with domicile and residence and actively contradicted domicile and residence needing to be a fact when it comes to birthright citizenship. So just because it was the fact of the case at hand, it was repeated at the beginning and the end, that doesn't control the holding, particularly not in this case when they have exhaustively over 30,000 words described every permutation of how this could work and clearly said, if you're not the child of a diplomat or an enemy occupying force and you are born here, you are a U.S. citizen. It is a done deal and has been for over 100 years. So, while this should be a unanimous decision, a 9-0 decision, well, I don't think that there's any way any reasonable jurist could view this otherwise or decide that somehow Wong Kim Ark does not control this. I suspect that what we're actually going to see is a decision much like the tariff decision, where the majority, including Roberts and Barrett, side with the liberals and Gorsuch stakes out his own little piece of land, and Thomas and Alito are just too afraid to ever offend Trump to make such a ruling, and so they will dissent in somewhat flamboyant and nonsensical fashion. That's what I anticipate. Now you know what you should know in order to listen to the arguments in front of the U.S. Supreme Court, and if there's anything worth talking about after those arguments, we will come back and fill you in. That is all for today, and thanks for joining us.